A decision in early September allowed Google to avoid a breakup of some of its most important components, one being its Chrome browser. It will, though, have to start sharing search data with its rivals and do away with the exclusivity agreements it has netted billions of dollars through. To discuss the ruling, we are joined right now by Herbert Hovenkamp, who is professor of legal studies and business ethics here at the Wharton School. Herb, great to catch up with you again. How are you, sir?
Thank you, and good to see you too.
Good to see you as well. So the ruling itself, what was your reaction?
It was very much in line with what I expected. Uh, Contrary to public belief, breakups in antitrust cases are really not all that common. Only a minority of monopolization cases result in breakups, even when the defendant is condemned. The typical relief is some kind of injunction, which either prohibits the defendant from doing certain things or else mandates that it does certain things. So this was entirely in line with that.
What should the consumer take from this ruling?
I think the most important part of the ruling is the one you suggested a minute ago. Judge Maida required Google to share its search index data. Now, that's an enormous database, very likely the biggest database in the world of web pages. Anything that's ever been crawled by the Google search bot goes into that index data. And basically, Google's going to have to give a group of qualified rivals. We don't exactly know how many that is, but I'm guessing it could be as many as a half dozen, a copy of that data. And that would kind of, in the judge's eyes, level the playing field, give them a chance to improve their search quality. And one of the hopes would be that some of these other search engines would be able to increase their market shares. For example, Bing, which is owned by Microsoft, a firm of roughly equal size to Google, has only about a 4% market share as against Google's 90+%. DuckDuckGo is now less than 1%. Yahoo is down in the same area. So the belief is that by sharing the index data, the market shares of these rivals will come up and we'll get a more even competitive field.
So it's an interesting question you bring up right now, is the fact that for the most part, the consumer is used to using Google. And I guess the question becomes is how much might consumers switch away from Google and go to some of those other platforms that you mentioned? Or does the convenience of what people have used, despite the component of a potential monopoly, does it not have as much impact?
It's a good question. Two things about consumer behavior. Number one, yes, they get habituated to certain things. Number two, however, switching costs in search are incredibly low. I mean, you don't have to register. You don't have to give them your life history. You don't have to give them your credit card. You can go on any search engine you want. The sticky thing, which has been the subject of this litigation, has been default search engines, where Google paid boatloads of money to firms to make Google search their default search engine. Even on those devices, like iPhones, for example, you can switch defaults, but very few people do. So the judge in this case really did not give the rivals any major thing to pressure consumers to switch other than improvements in the quality of competitors. They will be free to switch if they want to, but there's no real stick that forces consumers to switch.
So we're in a time where artificial intelligence is starting to have a greater impact. And one of the suggestions brought up in some of the articles is just how technological advancements like AI and what we may see in the future could potentially impact this idea, this whole world of search.
This whole case was tried with very little reference to AI. And that trial was, about a year and a half ago now. So these AI developments have been very recent. The judge is clearly blown away by them. Half of this opinion is about the impact of AI, but the problem is there were no findings about AI in the trial record. And right now, the market is up for grabs. I don't think anybody can say categorically who's going to win or whether there will be a winner in AI. One of the things AI permits is very much more product differentiation in search. That has always been a problem with search is it's not sufficiently differentiated. So, in social network sites where you've got lots of different platforms, we've got fairly robust competition. But search has not been able to achieve that. So the real loose cannon in this situation is what's going to happen to AI, and will AI permit firms to differentiate their offerings and establish themselves a little more strongly so that maybe 4 or 5 years from now we see a market that looks a little bit more like, say, the social networking market, where you've got several substantial firms and viable choices among them.
But realistically, we're still a ways down the road from a time, and you kind of just alluded to this, where Google loses its dominant position because the others' positions were so small that they are going to need to have time to build up.
We're certainly talking about years rather than months, but it could happen. One thing about digital content is consumers can switch quickly if they want to. It's not like a house or something where you have to go through a major event in order to get rid of it. They
Yeah.
can switch quickly, and then the only question is whether they will.
Herb, great to catch up with you and get your thoughts. Thank you very much.
Thank you.
Herbert Hovenkamp, who is a professor of legal studies and business ethics here at the Wharton School.